State versus Mark Lunsford. Can I have parties announced?
Austin Stout for the state.
Dan Coggo and Sam Log from Mr. Lunsford.
And are you Mr. Lunsford?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, sir.
Counsels, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
Any objections?
No, ma'am.
Just like that, 54 charges vanish. This is almost unheard of. Why would the state give up so much leverage? The answer is in the plea deal they've already struck, and the numbers are staggering.
Mr. Lunsford, did you review the document entitled, just one moment. Did you review the document entitled Court Admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with money laundering? Everyone, please whisper. Did you understand you're charged with the offense of money laundering less than $300,000 as a first-degree felony? Range of punishment is anywhere from 5 to 99 years in life and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
We discussed the defenses with it, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him?
I-
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Lunsford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a United States citizen, by entering into this plea bargain agreement, you can be deported, not allowed naturalization or re-entry into the United States?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on count 1. They're asking that your punishment be assessed at 10 years in the prison. There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,276.34. And you will not accept or maintain employment in any position involving the handling of financial transactions.
Paying back nearly $300,000 is a huge admission, even with a no contest plea. But the most restrictive part of this deal isn't the money. It's the one thing he's now banned from doing for the rest of his life.
Counsel, could you all check the box here? An
Yes, sir.
initial. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
With the caveat that the state was going to recommend probation. Thank you.
No, they recommend probation, but they're opposed to the deferred.
Yes, ma'am. You just.
Sorry.
You said they're opposed to defer.
All right. So did you understand that to be the plea?
Yes, sir.
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Yes, sir.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand? All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bear County Jail, no contact with the complainants listed, and felony anti-theft course and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to count one, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
The state is offering State's Exhibit 1 and all attachments. And Your Honor, I would just want to clarify for the record that count 1 is first-degree felony, but it is for money laundering over $300,000, not less than.
All right, thank you.
The prosecutor just corrected the judge, making the crime sound even worse. This should give the state more power, not less. It makes the decision to drop those other 54 charges even more confusing. What is the state not telling us?
I think what do you call it? The sign is incorrect. You know, when they do the sign, the less than sign and the more than sign. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Sure.
Did you understand it and sign it in all the appropriate places?
Yes.
And counsel, I'm assuming you have no objections to the stipulations being entered?
We do not, Your Honor.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, there's a stamp over the discovery.
I saw that too, Judge, a postage stamp.
Oh.
That made its way into the document. I wasn't sure what that was
So I'm not
about.
able to read that. If I lift it, it tears.
I can get another copy, Your Honor. It's going to take me a little while.
All right, no problem.
Okay.
You can't make this stuff up. A simple sticky note has literally covered up a key piece of evidence. While they sort this out, it gives us a moment to consider. For a case this big, the proceedings feel strangely routine. Is this justice being streamlined? Or is this a deal that was made long before anyone stepped into the courtroom?
And this is why I took math in school. So Mr. Lunsford, what's taken the court a while is that because this is submitted to me, I have to find that there's sufficient evidence to find you guilty. So I have to do my math to make sure this adds up. All right?
Second chair.
All right. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We'll come back here for sentencing on October 20th. Your court date will be at 9 a.m. I will base my decision upon any evidence that's presented.
Sure.
All right. Anything else before we go off the record? All right. Once you sign the reset form and speak with probation, you'll be excused. All right. Thank you.
Thank you, Your Honor.
Thank
Your
you.
Honor.
So, after all that, there's no final answer today. Mark Lunsford walks out of the courtroom with his fate still hanging in the balance. The judge has accepted his plea, but has pushed the final sentencing months down the road, leaving him and the victims in limbo. This brings up two critical questions. Will the judge ultimately agree with the state's recommendation for probation? Or will she decide a first-degree felony of this scale demands a tougher sentence? And what does it mean for the victims to have to wait even longer for a final